Well, good to have you join us once more on International Forum. Well, a Colombian judge on Friday sentenced still powerful former President Alvaro Uribe to 12 years of house arrest after he was found guilty of witness tampering. And the sentence which really marks the first time in Colombia's history that a former president has been convicted of a crime and sentenced. Uribe, who led Colombia from 2002 to 2010 and defined domestic politics for a generation, was found guilty of asking right-wing paramilitaries to lie about their alleged links to him. While in power, Uribe led a relentless military campaign against drug cartels and the FARC guerrilla army. He remains popular in Colombia for his crackdown, despite being accused by critics of working with armed right-wing paramilitarians to destroy leftist rebel groups. And this all started on the 25th of October 1997, where the paramilitary groups descended upon the remote 300-person farming town of El Aro in the Colombian state of Antioquia. Over the next 5 days, the drug-running paramilitaries slaughtered 17 people and raped multiple women, burned town down, forcing the remaining townspeople to really flee from the town. The attorney, Jesus Maria Vell, had been pleading with the state governor, who was then Alvaro Uribe, for over a year to stop the paramilitaries' brutal takeover of the countryside and collusion with the military. Instead, Uribe labeled Vell an enemy of the armed forces. In a statement to prosecutors after the El Aro massacre, Vell asked for a full investigation into what he described as an alliance in Antigua among paramilitaries, the military and Uribe, to kill civilians and seize their land in the name of fighting the country's left-wing FARC guerrillas. Within days, two men in suits strode into Vell's lawsuit and gunned him down. He was shot dead, but on August 1, just a few days back, Uribe, who went on to become Colombia's president in 2002, was sentenced to 12 years of house arrest after a Colombian court convicted him of bribing a witness who had linked him to the paramilitaries. The conviction could still be overturned anyways on appeal, but the fact is that it has happened at all is a striking development that would have really seemed almost inconceivable a decade or so ago in a time of rising autocracy and abuse, including in the US. It also offers reasons for hope. And we explore this historic ruling, which we will be looking at lessons learned, not just for Colombia's democracy, but for public office holders everywhere. What lessons lie in Uribe's fate for those entrusted with power? How do we draw the line between leadership and accountability? Welcome once again as International Forum, and I am Philip Omo Gyupon. Joining me to look into this, I have a legal luminary and the person of Emmanuel Obakbolo right in the studio with me. Good afternoon.
Good afternoon, Philip. Good afternoon, Nigerians.
Also, joining me via Zoom, I have Matthew Ederase, Esquire. Good to have you join, Matthew.
Thanks for having me, Philip.
All right, before I swing the pendulum to you, Matthew, let's get your thoughts about this. All this development, in Colombia, and of course the ex-Colombia President Uribe. What do you see as a significant, impact on the democratic leadership in Colombia, and of course that of the judiciary?
And I think one of what I think about this ruling, as it is called, judgment, is a welcome development. It signals something good, and it also enshrines the principles of democracy in Colombia, wherein this ruling will spark a lot of anxiety. It will spark a lot of hope for democracy in Colombia. And it has gone to manifest, like I did say, one of the principles of democracy, where you talk about equality before the law. It goes to show that all humans in Colombia are equal before the law. Despite the fact that the man has the toga of a former president of Colombia, yet the judge, that is Judge Sandra Juliana, was bold enough to have taken the stride of ensuring that wherein the facts before her and the evidences presented to her upon evaluation, the man was found to have committed those offenses, because one of the offense was that he was alleged to have committed trying to bribe a top government officials, and also about on corruption, which you hardly see from that jurisdiction. Particularly, Colombia is a Southern American country where you have countries like Venezuela, Brazil, Argentina, Chile, Paraguay, Uruguay, and others. Yet, we're able to see an example following the kind of the European democratic style, where you see that no matter the toga you possess, no matter the name you bear, no matter your array of titles, where you go, you contravene the law, you pay for it. So it goes to show that Colombia, the judiciary in Colombia has indeed woken up. The man has right of appeal, and he has gone on appeal, as the case may be, but yet we have an historic day wherein the judge was bold enough to have made that ruling.
Well, we don't know what your bite is like, but looking at what we have, in the country Nigeria, we still have issues about the judiciary and, of course, what it has to do with the democracy that we practice. But how do you welcome this development in Colombia? And, of course, your bite on the impressions it has on the judiciary in Colombia. Matthew.
The development in Colombia is democracy cannot be discussed without a proper mention of the rule of law. And auxiliary to that rule of law is the equality of everybody before the law. And the principle that no one is above the law of the land. That is what that judgment or ruling have demonstrated in Colombia against the former president of that country. The law is not meant for the citizens and exempting the leadership class. That aberration is rife because, in most jurisdictions, because the rule of law So what the judge did is what is expected of him as an arbiter. Any case presented before a court or before a judge should be treated dispassionately. Facts should be married with law, and the decision thereafter should be respected by all. There is no other duty of a judge or an arbiter other than to apply the law to facts. To do otherwise is corruption. And when there is corruption of the judiciary, you will not see results like what transpired in Colombia. Justice should be dispensed with courage and sincerity, with strict adherence to the dictates of the rule of law. Independence of the judiciary is only possible where judges are ready to assert themselves. Nobody will give you independence when you are leaning towards subserviency. If the judge was kowtowing to the dictates of the executive in Colombia, there would have been no possibility for that judgment to take the form it took. Coming to our judiciary in Nigeria here, for instance, we have seen how high-profile persons who are politically exposed, they face trial and it becomes a show of grandstanding, and the judiciary are reluctant to wear the hammer. But when it comes to the ordinary peasants, the ordinary man on the streets, there is always swift justice and there is strict application of the law in such cases. Because if the judiciary is a respecter of the high and mighty in the society, we expect the result that happened in the Colombia case. And that is what we should encourage in every democratic nation. You cannot be discussing democracy without discussing the rule of law and equality of all before the law. So that is just the lesson to learn from that development.
You know, a lot also say that this is the first time happening in Colombia history. Well, let's see developments, you know, in the time past. Probably there could have been possibility of the rot in the system. And what do you think brought in the bold and, of course, the change narrative and the course of action that the judiciary took in this particular case of Uribe?
Yeah, I would want to commend the judge who came up with that strong, bold, and courageous judgment, arriving at that the judgment in the form and manner it went. Also, it goes to tell, because that environment, that atmosphere, Colombia as a country. Colombia is a country where you have very strong cartel of different variety, cartel of different magnitude you find in Colombia. You would want to, at a time, compare Colombia, Venezuela, in the kind of practices and activities you see within that jurisdiction, particularly in relation to drugs and other things. But here we are. One man can make a difference. One woman can make a difference. One boy can make a difference. One girl can make a difference. And a group of persons can also make a difference. That is what it has gone to show in this judgment. Despite what the environment is known for, despite the abuse of the principles of rule of law as it has been within that jurisdiction, and as we see here in our own jurisdiction, despite all of that, one person, one man was able to say, no, I will make a difference. So it's a clarion call to all, whether the mighty, whether the small, whether the little, as the case may be, that you as an individual, in trying to dispense the responsibility that is given to you, you can make a difference. Whether or not any person or anybody is watching, you can make a difference. Today, the judge is taking all of the praises, as the case may be. Here we are discussing the bold step taken by one man in faraway Colombia, in our own country called Nigeria. So, whatever any person may want to look at it, is that it should be seen that no matter the position you find yourself in life, and in your community, in your state, and at the national level, in the local government, whatever responsibility that is vested on you, you should do it in consonant with the laws. So that at the close of the day, you will not just have clean hands, you will have immaculately clean hands. And in the case of Alvaro Uribe, it goes to show that despite the fact that when he was at the end of affair in Colombia, he chased a cartel. He was able to chase them. He was able to do a little turnaround. But at the same time, he had another gang that was carrying out operations, that was ensuring that all oppositions were put into total silence. But he never knew that a day will come where himself will be made to face the law. And whether or not the law will smile at him, or whether or not the law will shy at him, or whether or not the law will visit him with the principles, tenets of the law, to ensuring that the law is carried out ultimately. And that is what the law has just done just now.
Okay.
So now it is a lesson to every one of us. When you look at the jurisdiction that this judgment comes from, you would want to compare it with that of Africa. So, can an African judge make a difference?
Okay, we'll come there, but it's not over yet, because we have this conviction, and of course he has a right of appeal going forward. But let's get your bite also, you know, Matthew Edega say. looking at what is before the court, and of course the possibility of him, seeking victory in appeal. What do you see about the strength of the judiciary in Colombia? Do you see this as an opportunity for the judiciary to be tested? And of course, can you say that there is basically going to be a twist or a strengthened course whereby justice will be upheld by the upper court?
Like every other case, or in every other cases, when an appeal is lodged or filed before against the ruling of the lower court, nobody can say with certainty what the higher court will do. But what can be said is that if there is no bias, and there is no corruption, and there is no intimidation on the part of the judges, the laws will be looked at dispassionately by any judge in whichever capacity, either as an appellate capacity or in the court of first instance. The same standard is expected of every judge that is sitting over a trial in any case. So the higher court does not have a separate standard to apply, apart from the standard of justice and the rule of law. If there is any loophole in the decision, and the loophole is highlighted and the judges look at it dispassionately and meritoriously, the judgment could be overturned. But that does not take away the fact that the lower courts arrive their decision with courage and fearlessness against a very important personality in that country. What the lesson to learn, whether the judgment is upturned or upheld, is that judicial independence depends on the assertion of the people who sit on that who sit in judgment as judges in courts. Independence of the judiciary cannot be guaranteed if the judges are not ready to enjoy it by asserting themselves. When you begin to act with fear as a judge, you fear certain personalities and authorities, you are likely not to benefit from that constitutional guarantee of the independence of the judiciary. So we are not as concerned as what the outcome of the appeal will be, as we celebrate the courage of the judge at the lower court who has delivered this historic ruling or judgment.
And Uribe said that, well, he's not guilty of what he's been charged. And so basically it's going to be, addressed at the Court of Appeal. But do you see the possibility of a political witch hunt in this process?
Well, we are not opportune to be in Colombia just now to know the style of leadership, particularly with the current president of Colombia. But from this judgment, I would want to say that I don't think there could be any form of political witch hunting, because the witch hunting would have come before the judgment was delivered. Like in our climes, we have seen also where some judges who are bold, who are courageous, take some giant strides to give judgments. We have seen, particularly in the 70s, in the 80s, and the early 90s, during the military era, we had judges who were bold enough to confront the then military junta with their judgments. You see sound judgment. Some of the judgment, when you are reading it, even you must not be a lawyer to enjoy the lines of the judgment. As a citizen, when you are reading those judgments, the lines alone, they are very poetic, they are sound, the grammar, the sentences, the paragraphing, you begin to see sound writing. And you know that, yes, this judgment is coming from a sound mind. Unlike in a situation where even the recruitment of the judges is questionable. That is where most times you find corruption. It's not that most of those judges who don't stand on the law, who don't look at the principles of the law and marry it with the facts and figures before them, not that they cannot really do it at times. But when you look at where are they coming from, how did they get there, who made them this judge, then you begin to look at the political and bias angle of their recruitment. And that is why at times we end up in situations where judgments are being changed or are not holding the tenets of the principles of law as it ought to be. But in a situation where, like we saw Sandra Juliana has done in his own part, we saw that the judge, I was watching the video, you see the confidence of the judge, the confidence while delivering the judgment, very, very confident. You see the courage. And at the close of the day, for Alvaro Uribe to say, I am not guilty, he is guilty as he stands. As he stands now, he is no longer a suspect, neither is he a defendant, but is what? A convict, as the case may be. So maybe, as he has appealed, pending the final decision of the appeal, for now, is guilty as charged. And he is a convict, and the judge has taken a bold step to ensure that all that was brought before me, I went through them, I have seen it. So let's see whether or not it can succeed on appeal. But before then, just now, Uribe is a convict, and the judgment just now has shown that he's a guilty man. So he stands to be guilty until the table turns to his side, maybe to favor him. But I think that this one, the judiciary in Colombia may want to make a mark.
Well, this actually is a twist in the history of Colombia, and many are really saying that, well, it's a welcome development, but let's see how it pushes forward. Why some are also critiquing the fact that, well, why should it be a house arrest? What do you see as the peculiarities, you know, in making this punishment or retribution at the first instance at the court, and of course saying that it's going to be a 12-year house arrest, probably in the course of action. They may come with, that may come with a fine. Do you see some unique or peculiarities as regards this conviction by the judiciary? Matthew.
When you are convicted and the laws of the land prescribe sanctions for certain offenses, the judge is it's at the discretion of the judge to apply any of the available sanctions. I think house arrest is one of those sanctions for a convict. I do not think anybody should take the house arrest conviction as a walk in the park. Take yourself, for example. For instance, if you are restricted to your compound for 1 week and you can't step out into the street, you can imagine the psychological torment. You think it's easy to stay in your house for 12 years without stepping out of your premises? That is imprisonment. Imprisonment is confinement of human movement. Freedom of movement is restricted. Whether you're restricted to your house, be it a martial or a hut, or you are taken to the common prison meant for other convicts, your movement is restricted. And your freedom of movement is very vital to enjoyment of human life. If that is tampered with, when house arrest or confinement in prisons, public prison, you are undergoing a terrible sanction. Nobody should downplay the impact of being placed under house arrest for 12 years. We're not talking about 12 months here. If you restrain me from getting out of my house for 3 days, I will be under serious psychological torment and torture. So house arrest is not fun. Restricting yourself, convicts, to remain in a particular geographical location, and it mustn't move beyond that point, even if it's a 300-meter radius, is undergoing serious sanction, and that is punishment by every standard. It's not fun to be placed in a confinement for 12 years.
Thank you. Let's get your bite on that, Emmanuel Obakolo.
Like I did say.
Okay, you still have the floor? You still have the floor?
Okay.
Yes, especially for personalities who are accustomed to living a life of luxury, like the ruling class. You know, they are good. They are used to moving from place to place. They fly in airplane, private jet, and all of that, and they go to a holiday resort and they go on boat cruising. So if you put such person in one location for 1 month, it might even affect his health adversely. So it's a very serious punishment to be confined to your house for 12 years.
Thank you very much, Matthew. Well, let's get your thoughts on this because it could be that we don't know the laws, operational in Colombia, but it could be that maybe those in the political class, whatever punishment that could be served them, could be house arrest. But let's look at the gravity of the house arrest. Even though Matthew said, well, it's a form of punishment, that it's also very, very, grievous, and of course, that's enough to punish one who has been enjoying the office, the public office for years. So. But you see this as unique, or should there be stringent measures?
Well, it depends on what the law provides for over there in Colombia.
Okay.
And I don't want to look at the manner of the sanction, but I want to look at the sanction itself. Why was he sanctioned?
Yeah.
It goes to tell that the man was guilty. He was sentenced, then now the man has been convicted as he stands until the table turns to his favor.
Okay.
The man is a convict. He is. So, one, to confine a man.
Okay, I'll come back to you on that. You take off from where you left off after this short break. Do stay. Thank you for still holding on as International Forum, and we're still on the aspect of the ex-Colombian president in the person of Alvaro Uribe that was sentenced to 12-year house arrest in Colombia. Of course, he also has a right of appeal, and basically he will be, deploying that, utilizing that to make sure that he is able to get justice in his own perspective. But this is someone who, has been in power, even while he was the governor, of the Antigua state in Colombia, and of course, all that transpired over there. It also shows the fact that, he has been in governance for quite some time, and looking at the need for justice to be made in the course of what political actors do while they are in power becomes an essence for which the judiciary will have to, lay this big blow on the person of, Uribe. But well, before we took that break, Emmanuel Obakpolo had the floor.
Yes.
Can you ventilate?
Yeah. Now imagine that the man is the type that goes for foreign medication. Imagine that the man is the type that goes on vacation, holidays. Imagine that the man is the type that always want to visit every Tom, Dick, and Harry, goes to functions, go to other things. Imagine that. Now, a restriction to his freedom of movement has been placed, and is confined to his house. So you cannot now say that sanction is liberal. You cannot say so.
Okay.
Damage has been done to his freedom of movement, to the extent that the man is confined only to his house. So what next? What would one have thought, or one would have envisaged should have happened to him? Should it have been a death sentence? That is when somebody will say, oh, the judiciary is really doing beautifully well or pretty good in Colombia. No. The sanction, to my mind, is enough. The sanction is a wake-up call to other top-profile personalities, VIPs in Colombia, that look, someday it could be your turn. So, hence that this man will be cited in the history of Colombia as an example of the law, someone, despite the toga he bears, but the law was visited on him. How I wish we can have a situation like that in Nigeria, where whether you call it confinement to his bedroom, whether you call it house arrest, whether you call it whatever nomenclature you are going to give to the sanction, but the law is visited on a top personality
Okay.
like Uribe. I think that is what we should be thinking of, and I think that is what every other judiciary, particularly from Africa, should look at and say, look, we can also make a difference. From the outset, I did say that it is a wake-up call to tell every one of us that as an individual, you can make a difference. I think the judge has made a difference here.
Well, looking at what transpired, we can take our memory back to, in the small town of El Aro, where Antigua, Colombia State, is based. And of course, he started off while he was governor of the Antigua State of Colombia. And of course, all that transpired even when the attorney warned him about the paramilitary groups that seem to be threatening civilians, in that small town of El Aro. But in 5 days operation of the paramilitary groups, 17 civilians were killed. And of course, this again brought to the attention of, the attorney that also brought this issue before the governor then, who was still Uribe in 1997. But rather than, instead of Uribe to look into this case, Uribe went on even blaming the attorney, saying that is he taking side, with the left-wing FARC. And all that transpired seemed to be a challenging course in democracy, most especially when it's been saying that, Uribe, while he was governor, and of course, he won the heart of many, and of course, even if he was not able to find his way into the hearts of many, he wouldn't have been able to later claim the office of the president in 2002. And ever since, it's been seen as very influential. But some are asking big questions. What is the, reward for serving your country? Because he is seen as one who served this country judiciously. And of course, looking at what transpired, some have said, should there be post-tenure immunity for public office holders who, in the course of doing their job, could find themselves wallowing in some shoddy waters, and then by the time they are done with the, political office, they are being thrown overboard, and then they are being faced with, litigations left, right, and center. Should there be a post-tenure immunity to, protect these public office holders after office from being, treated with ignominy, as some would say? Matthew, I don't know if you got my question. Okay, before I come to you, Matthew, I believe you got my question, because there is this question that there should be post-tenure immunity in order for public office holders not to suffer public shame, like what we could see Uribe is suffering today. Do you subscribe to that?
No, I cannot subscribe to that. That would make the person a demigod.
Wow.
A near God. Because by the time the person enjoys the protection of the law, the immunity clause while in office, and you are now thinking that so that if the case of Uribe, who did well as a governor, but also I did tell you, while he was in office, he did well.
Yeah.
On the one hand, but on the other hand, he also had a gang. He was busy chasing the cartel.
Yes.
Are you getting me? He was chasing the cartel, but he had a gang, and his gang, he was also using his gang to perpetrate the same thing he accused the cartel of.
But to deal with a cartel, you need a force.
Is that a room? Does the law now say you must have a gang? Like the one we saw here in Nigeria in 2020, if my memory judges me correctly, the killings at Lekki Toll Gate. Till today, there's absolutely nothing, no evidence to show anything. You just hear story. However, it brought about the what we now know as the Police Act, 2020 Police Act. But then, those suggestions that were made, are they really in practice? Was anybody indicted? Was there any form of sanction? Was there any form of compensation to the victims, to family of the victims? Was there anything? Or we have a situation where till today some persons are still arguing that nothing happened at Lekki Toll Gate. But we saw in the case of this judge, we saw in the case of Uribe, that look, you enjoyed immunity from 2002 to 2010. You enjoyed immunity for 8 years. Then that was enough for you. Now that you left the office, once upon a time, you had a gang that committed crime in your name. So what do? The law must have its course. And the law has its course, and here we are with the judgment that has been visited on him. So we should have a situation where every man will one day stand before the law, and the just cause of the law will be visited on that man. There is no amount of after enjoying protection while in office, you still want to enjoy protection out of office. Then you can also say that the man should enjoy protection in death. That should be the next level. So we want to, I want to state here and now that look, the enjoying protection after leaving office, it's another form of madness. So what should have been done is what has been done. We have in our own climes, the law protects top government officials, particularly the president and the governors. The law protect them
while in office.
While in office. So when they leave office now, we now say the law should, this man will do signs and wonders without miracle. So it is better the way the law is, that after office they cannot face the law, just as it has happened in Colombia.
Okay, let's get back to you again, Matthew Adegase. Before Emmanuel Obakpolo took the floor, we were over to you with a question, and we took a swipe to, El Aro town, where this whole thing started in 1997. And of course, the 17 civilian lives that were slaughtered in the process by the paramilitary, groups that not only slaughtered the civilians, also were involved in multiple rapes. And of course, the killing of the attorney that even warned, Uribe, who was then the governor of Antigua State of Colombia. All of this raged on. But if we look at what transpired, in the build-up of the political, sagacity of the Uribe as president. He was governor then in 1997 of Antigua State, and then he rose, found his way, won the hearts of the citizens, and he became governor in 2002. Questions have been asked. The possibility of the fact that when someone is in office, he could act, using veto power to some extent within discretionary powers that is given. But again, there could be some accidental, happenings that the law could find him wanting over. And so basically, one of the reasons why they say that there should be, immunity for public office holders. But some are saying there should also be a post-tenure immunity to protect them from ignominy after leaving office. Do you subscribe to that?
If we are placing the issues in the right perspective, immunity for political office holders or for leaders, it's not meant to grant them the license to commit atrocity in the course of their public responsibility. It is only meant to protect them from distraction while they are discharging the function of their office, with the intention or the expectation that they will always do what is right before the law and within the law. Immunity does not give you the right to be lawless as a leader. And if that immunity were meant to protect their focus on their duties while in office, to avoid the distraction of going to court to face litigation and all of that, over criminal indictment and all of that. But after you leave office, why should anybody be wishing or clamoring for extra or post-tenure immunity? That will amount to impunity. That will no longer be immunity. After you have finished your duty, there must be accountability. You must be accountable for your actions. If you make omissions, that may be excused. But when you commit an act that is purely unlawful or criminal, outrightly criminal, you must face the consequence upon your exit from office. So to demand for immunity after tenure has elapsed, we amount to granting a license to leaders to be reckless with power, and that will be deadly to the ordinary citizen of the land. If he had done anything as the president of Colombia that is allowed by law, nobody would have been making him to face prosecution. That would have amounted to execution. And the very fact that he was made to face the courts and stand trial, if he had any defense, he was having the opportunity to present them. And in this case, I'm sure all of that was done. And the verdict was against him, meaning the prosecution had their way because they had the facts. If the prosecution has the facts, and the facts are supported by law, why will conviction not be natural? And why will anybody be arguing that or suggesting that he ought to have been forgiven or allowed to get away with infractions or criminal acts while in power? That will not make any moral sense or even sense in law and logic. There must be consequence.
Okay.
There must be consequence for bad behavior.
Okay. Well, I asked you that question to ask you the next question because it seems to our minds, or some of us, that there seems to be a post-tenure immunity in some countries of Africa, because we see situations where even then former, head of states, though not under a democratic government, publish books and they confess their sins of what they did while in power. They seem still untouchable. How do you say this as a digression, making a comparative analysis between Colombia and Nigeria, our home country, our fatherland?
We should not mistake an aberration for a norm. What is not good is not good. We cannot decorate it with the garb of fairness and equity. What is happening in Africa, in most African states, it's an aberration to the principles of rule of law and democracy. If you have governed a country and you enjoy immunity while you're in office, when you exit office, you should be subjected to account for your tenure. And if you are found wanting, you should be made to face the law. People wrote books that could pass for confessional statements of their involvement and role in the atrocities that took place under their watch with their active participation or authorization. What is happening in Africa is just you scratch my back, I scratch your back kind of gangster patronage. Because the person who is in office is doing the same wrong that the predecessor did. So the fear that if he exits office tomorrow, he will be called to account, compel him to begin to protect his predecessor from prosecution after office. So there is no lawful immunity granted to people in Africa, post-tenure immunity. What is happening in Africa is a post-tenure protection by their comrades in crime, their allies in crime, because we are having the issue of recycling of leadership. The same people are recycling themselves within the circle. So if you have a gangster running a system and none of them want to do the right thing, be very sure that they are likely to circumvent the law and create a system that will grant impunity even when they exit office to them. That is what is happening. It is not a norm. It is an aberration and an anomaly.
Thank you so much.
That we must confirm.
Thank you so much. Let's get your thoughts, Emmanuel Obakpolo. He said it's an aberration. But what makes it difficult for the system in Nigeria to make them accountable for what they did, even while in office? Because it seems to our minds that they seem to enjoy post-tenure immunity. What do you think?
Yes, that is what we have come to see. But the law frowns at it. It's unfortunate that we have persons who are of like minds, and they've been able to find their way to leadership positions, and during and after their tenure in office, we see what I would want to refer to as participes criminis, partners in crime, where they have protection from those who took over from them. But what is the position of the law? Does the law allow for that kind of protection? The answer is a capital no. But we see, just like Melanie Senior said, in this kind of situation, you arrive at a first class impunity system. And that is what we have come to see. That's why you see even upon the death of one, you will see the conversions of others, like the marriage party of vultures, where they will converge and begin to see how they can protect their own. And you see they give national honors, they award national honors to the dead, and they begin to say all manner of things.
Posthumous award.
And that is a terrible signal that, look, we are not yet ready to come out of this kind of quagmire we find ourselves. But we do hope that someday a man will come like George Juliana, who stood despite the tide, swam against the tide, and came with a nod.
Thank you so much, Emmanuel Bakpalo, and thumbs up to you, Matthew Edegase, for being part of this discussion. Well, to you viewers, awesome to you and you're so amazing for having us, serve you this beautiful, episode on International Forum. Well, a lot has been said, and there's always a difficult process when we juxtapose comparatively, between the developed polities and the underdeveloped, or let's call it developing polities. Nigeria happens to fall into, the category of developing polities, and of course, there's need for us to make the democracy of the Western world and see how it can, work for us in order to bet a liberal democracy. We'll continue to interrogate the process, and we hope you join us sometime next week on the program International Forum. From me, Philip Omo Gukmo, is bye for now.